morning. My name is Pamela Price.
Just don't want to get in your way.
Yeah. Shorter than most people, which is okay. My name is Pamela Price, and I'm the former elected district attorney of Alameda County, and I'm here today to share with the public a preview of my open letter that we will be publishing because I felt it's important that the public should know what has actually happened since the appointed district attorney has taken office. I'll start with the Radius Reliance case, which was dismissed unceremoniously without notifying the victims of that crime and without providing the public with insight into the basis for that decision. And why that's important is because there are statutes of limitations against that could be brought, or for crimes that could be brought against the company that are going to expire within a few weeks. So we have very little time to try to recover what should have been a very important piece of litigation on behalf of the consumers of Alameda County, the residents, excuse me. As many may know, a criminal grand jury was convened under my administration. There were approximately 16 residents of the County of Alameda who were brought together, who swore to, obviously, just like any jury, to look at the evidence in a neutral, unbiased fashion and make a decision. That criminal grand jury voted to indict Radius Reliance. There were 10 counts for environmental crimes. The testimony took approximately 4 weeks, and I can attest that the team that presented that testimony for at least a month or more spent 6 months looking at the case before they presented the testimony. There were approximately 50 witnesses who testified before the criminal grand jury. There were thousands of documents, including emails and text messages, that formed the basis of the indictment. There was a public health expert who was called as an expert to talk about the impacts of air pollution and the release of lead, which there was lead found in the plume that floated across the Bay Area. And she talked about particularly the impact of lead poisoning on children. And there were firefighters who also were victims of that fire, who almost died fighting that fire. And the Bay Area Quality Management District fined Radius Reliance $575,000 for that crime. We indicted them with the approval, based on the grand jury's findings and the approval of the court. There were 10 counts. Several of those counts were strict liability misdemeanors, which means from a legal perspective, all you have to do is show up and show that what happened, happened, and the person who is charged with that crime will be held accountable. So the reckless and negligent release of contaminants was not the first time that Radius Reliance had, in fact, committed a violation of our laws. In fact, in 2021, the district attorney's office settled a case with Radius Reliance for $4.1 million payment. So this was not a unique situation, and it certainly was not a hard case to prove. And certainly for the victims, and I am a victim because I live in the East Bay, but there were 5 victims who testified before the grand jury. There were firefighters who testified. People who were directly impacted were not consulted about the decision to dismiss that case, and it is a travesty of justice that that case was, in fact, dismissed. And I should point out, she never talked to the lead lawyer. No one in the office talked to the lead lawyer, Gabriel Markoff, about the merits of the case or what had to be done to protect the case in light of certain court rulings. I want to also address the elephant in the room, which is the conflicts of interest and the corruption and nepotism around the death penalty cases. Ms. Jones-Dixon was hired by District Attorney Tom Orloff during the time that the United States District Court found that, quote, prosecutors from the office were engaged in a pattern of serious misconduct, and Black women and Jews were being denied their right to serve on a jury. She was a member of the office the new district attorney was a member of the office in 2005 when the prosecutors in her office, including her colleague, the Honorable Judge Morris Jacobson, circled the wagons against the truth when they attacked Jack Quatman and tried to undermine his credibility. They effectively did undermine his credibility to hide the true nature of the actions that the office was taking as a matter of policy, which was unethical and unconstitutional. Judge Jones-Dixon received her judgeship in 2013 with the support of Tom Orloff and Nancy O'Malley, just as they championed her selection to be the next appointed district attorney. I give that information for context, because in this context, District Attorney Jones-Dixon's decision to assign the death penalty cases and resentencing cases to Catherine Horner Cobalt is rife with a major conflict of interest, and it's very troubling. Catherine Cobalt's father, retired Judge Jeffrey Horner, presided over at least a half dozen of the death penalty cases where we found evidence of prosecutorial misconduct and Racial Justice Act violations. Catherine's father, Jeffrey Horner, presided over the Ernest Dykes case, the first case where we found the notes proving prosecutorial misconduct, and that was the case that triggered Judge Chambria to issue his order to review all of the Alameda County death penalty cases. In addition to the Dykes case, Judge Horner, retired, presided over the Delaney Marks case, the Michael Martinez case, and the Braylon Winbush case, which is still pending, which this office, under the leadership of Catherine Horner Cobalt, his daughter, and the current district attorney, have now moved to withdraw the sentencing recommendations in that case, where we know that that prosecution was tainted by racial bias and ethical violations. In addition, Judge Jeffrey Horner was a prosecutor in the Alameda County District Attorney's Office for 20 years before he was appointed to the bench. The death penalty scandal, those cases span from 1980 to 2014. Judge Horner was a member of the office also during that dark age of prosecutorial misconduct. To have Judge Horner's daughter supervising the resentencing cases and filing motions to withdraw sentencing recommendations in death penalty cases, some of whom were presided over by her father, all of which took us months to negotiate and formulate a recommendation, is really problematic and nothing less than a travesty of justice. To say that the victims in the death penalty cases or any other resentencing cases were ignored is absolutely not true. Before we made any public announcements about what Judge Chambria ordered us to do, we specifically created a special team of 3 advocates and an inspector to reach out to the victims. They investigated each of the death penalty cases, some of which went back to 1980, to locate survivors and offer them services. We curated and sent special letters to the victims in these cases. We also engaged the services of a nonprofit victim rights advocacy organization, Broken by Violence, to support our own assigned advocates in reaching out to victims and providing counseling and support services. Broken by Violence caters to mourning individuals and families impacted by violence, especially victims of gun violence. Broken by Violence convenes weekly support groups specifically for the survivors in the death penalty cases. We had a dedicated hotline that we publicized for survivors. We also engaged Men Collaborative, another nonprofit, to inform victims of restorative justice options if they wanted to, in full compliance with the law. So in the rush to cover up the prosecutorial misconduct by withdrawing the sentencing recommendations, the district attorney, the new appointed district attorney, has also forgotten that the victims in these cases include the defendants whose constitutional rights were violated. Men like Curtis Irvin, who the state attorney general stipulated to overturn his conviction. Ernest Dykes, who the federal judge clearly was prepared to find that his constitutional constitutional rights were violated, and we negotiated a fair and reasonable settlement. Graylin Winbush and Jack Friend, whose cases are pending, the evidence clearly suggests that they did not get a fair trial. As an officer of the court and someone who has sworn to uphold the Constitution, Judge Jones-Dixon has an absolute duty to ensure that justice is done for those men. We all have a right to the rule of law and not have it compromised by corruption or nepotism. The ethical concerns that she has expressed, the district attorney, the new appointed district attorney has expressed ethical concerns about the prosecution of landmark consumer cases on behalf of the residents of Alameda County. Let me say, the auto and insurance contracts with outside law firms were carefully vetted by county council and approved by the Board of Supervisors, not once, not twice, but 3 times we went to the Board of Supervisors. Those contracts had to be researched, vetted, amended, negotiated, and then approved by the Board of Supervisors. So if the new appointed district attorney had ethical concerns, she should have consulted county council, who is available to her, before she terminated those contracts. It took us more than a year to find and retain counsel and create that relationship, and she terminated those firms without ever talking to them and dismissed those cases in her first 2 weeks. So on the one hand, you have us spending a year to prepare to do these cases, and you have a new appointed district attorney who comes in and dismisses them within 2 weeks. And in fact, in addition to the approval by the Board of Supervisors, the California Supreme Court in 2011 approved exactly these kinds of contracts, allowing government agencies and prosecutors like this office, to create this type of arrangement with outside counsel. We provided you with the face sheet. The media that is here has the face sheet that has that case, and it has the holding on it. Specifically, the court held in exactly, and ironically, in that case, Alameda County was a party to that case under Richard Winnie's leadership as county counsel. And the court held public entities were not categorically barred from engaging private counsel under contingent fee arrangements, but retainer agreements were required to specify matters that contingency fee counsel must present to government attorneys for decision. That is in our contract, and that is the practice that we followed. That is the practice that was approved by county council and the Board of Supervisors, and there is absolutely no basis for the dismissal of those opportunities for the residents of Alameda County to receive as much as $33 million for someone to just blithely dismiss those cases. And I want to say that the criticisms of the team that was involved in those cases, quite frankly, is completely unwarranted. This is the same team that was able to successfully settle a $49 million landmark case with Kaiser. This is the same team, and in that situation, Alameda County voters received more than $7 million. This is the same team that was able to work with other governmental agencies on other cases. And I want to point out, the law firms that we hired had specific expertise in these kinds of cases, and in fact had been hired by other governmental agencies, such as Travis County, the state of Oklahoma, the state of Washington, and in days past, San Francisco County also hired private counsel to represent them. And as I pointed out, Alameda County was party to the Supreme Court case where the court ruled that this could be done. So if the new appointed district attorney had legitimate ethical concerns about what the scope and the work was of those particular cases, she could have met with the lawyers who were doing the cases. She could have vetted them herself. She did not do that. She did not talk to the lead attorney about the cases or or the lawyers who spent a year briefing us on the case and working with us. She apparently did not understand how the arrangement was structured or what restrictions were in place to protect the county of Alameda. And what I want to say that if she mentioned she might refile, well, there are statutes of limitations. So anyone who was a party of the case over the past 4 years has now lost their right to recover the damages from either the auto insurance fraud or the homeowner's insurance fraud. I think it's fair to say that the new appointed district attorney made a decision, a dramatic decision, without doing her due diligence. A case, again, that we took more than a year to evaluate and put in place, she dismissed within her first 2 weeks. That speaks of a carelessness that undermines justice and public safety and a lack of concern for the everyday people in this community. And that appears to be a theme. When you dismiss environmental pollution case, when you dismiss corporate cases, who are you protecting? You are not protecting the residents of Alameda County. She also dismantled the team that was doing extraordinary, exceptional work at the Consumer Justice Bureau. This is the same team that shut down the illegal vaping operation, manufacturing operation in Livermore, and set a national precedent and a model that is being followed by other jurisdictions across the country. This is the same team that I mentioned that settled a $49 million case against Kaiser that resulted in Alameda County residents receiving more than $7 million in restitution and damages. This is the same team that settled an environmental case against Walmart for $7.5 million. And I can tell you that that team had to modernize the internal case infrastructure. They had to clear out lots of irrelevant information. They had to account for billable hours that were not being appropriately tracked when we got there. So to the extent that there's some implication that this team didn't know what they were doing when they did these cases, that is absolutely not true. And it's a misrepresentation, as is the reason for, on day one, just like Donald Trump, rescinding the special directives. It sounds so familiar and so Trumpy. Those special directives, the reasoning that the DA, the newly appointed DA, has expressed, she had to get rid of the special directives on day one because they were slowing down the prosecution and that was interfering with the charging. Number one, how would she know? If you come in on day one, how do you know that? Number two, the special directive, if you read it, and we provided the media here with a copy of it, both the special directive on charging and enhancements does not apply to misdemeanors. Let me say that again. It does not apply to misdemeanors if you read it. The only backlog that was ever reported to me or the media was a backlog in misdemeanor cases at Wiley Manual. No one has ever said there was a backlog in felony cases that somehow was caused by the special directive. So that is not accurate and it's misleading. And I want to point out that misdemeanor cases form the bulk, generally always 2/3 of the kinds of cases that are prosecuted by most district attorneys' offices and certainly by this district attorney's office. You cannot put an enhancement on a misdemeanor. So to say that the special directive which governed the use of enhancements, which was based on SB 81, which was passed by the legislature to eliminate the use of enhancements in felony cases, to say that that is causing a backlog in misdemeanor cases is misleading to the public. There also was never a backlog reported or documented in juvenile cases. I must dispute that misrepresentation to the public. That department was fully staffed with 5 attorneys on the day that I left. I met with that team on my last day in office. They were fully staffed and that department was supervised by 2 veteran district attorneys in that office, Deputy District Attorney, Senior Assistant District Attorney Tiffany Gibson, who has 30 years of experience, and Senior Assistant District Attorney April Smith. The newly appointed district attorney also says that we never filed a wage theft case in 2 years. I must dispute that. In May of 2024, we obtained a $334,935 $34,935 grant from the California Department of Industrial Relations of the Workers' Rights Enforcement Grant Program to strengthen our investigation and prosecution of wage theft and forced labor cases. In August of 2024, we entered into a 5-year MOU with the United States Department of Labor to prosecute labor cases. When I left the office, we were collaborating with local unions, and we did that throughout my tenure, service providers, schools, and churches to combat worker exploitation and leading investigations in industries like construction, massage therapy, and street vending. The other issue which arises was related to Proposition 36. The newly appointed district attorney is correct. Alameda County is now leading the state in low-level felony prosecutions of property crimes. We are. And the data released by the California Judicial Council shows that, for instance, we're leading the Bay Area. In Contra Costa, before the newly appointed district attorney took office, Contra Costa only had 37 filings. We had 236 filings. San Francisco had 31 filings. We had 236 filings. We are on par to be with Los Angeles County, which is significantly larger than our county. And if the DA's mandate, she thinks under Prop 36, is to charge low-level felonies, well, I can report to the people of Alameda County that's exactly what you're getting. In San Mateo County, they've charged 43. We charge 236. So if you look, that report is publicly available. And in Marin, they have no charges under Prop 36 for felonies. But Alameda County, we have 236. And at the same time, she disbanded the organized retail theft unit that we created. We got a $2 million grant, successfully competed for $2 million from the state of California to form an organized retail theft unit. They went through extensive training for 90 days. I matched that grant with $2 million from our Consumer Trust Fund. The team trained extensively. The team was working closely with CHP and other local and even federal police agencies throughout Alameda County and Northern California. They trained loss prevention agents. They tracked arrests and cases and warrants and different groups that are operating in Alameda County and around the Bay Area. They were in direct contact with other district attorneys' offices to coordinate those prosecutions. And yet, the key members of that team were all reassigned or terminated. And so that team no longer exists. There is no one in the office right now who has actually gone through that training and is able to document the time and the goals that have to be documented under that grant. And let me point out, businesses are still being broken into, and people are still being shot, accosted, and robbed on the streets of Oakland. Victim Services, the newly appointed district attorney, says that she is prioritizing victims. Well, I'm here to tell you the Radius Reliance victims were not consulted. Where was Marcy's Law when their cases were dismissed? There's no treatment options for domestic violence victims at the Family Justice Center anymore. Why? Because the provider that we put in place has not been paid since November, and they are not providing. You have many conscientious, compassionate psychologists in this community who are ready and willing to provide those services to domestic violence survivors, but they have not been paid, and so they cannot provide those services. We hired 18 new victim advocates in our first year in office. My question is, how many has the newly appointed district attorney hired? Because the office desperately needs more victim advocates. When I left the office, we were fully staffed with victim advocates. We didn't have any positions available. In fact, we were completely fully staffed. The new district attorney says she does not know how many people she fired. Well, I do. She fired at least 10 attorneys, and another 8 have left. 1 is on administrative leave. 6 of the attorneys that are no longer employed in the office are African American. She fired 11 staff members, and one of them is on administrative leave. 11 of the 12 staff members who were impacted by these terminations are Black or Latino. This was an office that had a huge diversity problem, and yet you are focusing on firing Black employees who were doing the job. She fired people with expertise that were doing the work that we hired them to do and doing it very well. She fired 2 lawyers in the Public Accountability Unit and reassigned the chief of the division. Both of those lawyers between them had 40 years of experience. The Brady list that she mentioned was in fact available to law enforcement, and I was aghast to hear her say that none of the cases that we investigated were, that reports were not provided to the chiefs of police. There were 3 reports issued before the end of my term. A report in Augustine Gonzalez, which I personally contacted the chief of police and advised him of the findings and gave him an opportunity to object or to correct, and then we issued the report to him. There was a report on the shooting of Joshua Gloria in the city of Fremont. Again, I personally contacted the chief of police in the city of Fremont. I gave him an opportunity to review the report before it was released publicly, and we released the report to him. There was also a report, an exhaustive report, prepared in the death of Cody Chavez in the city of Pleasanton. I personally spoke with Gina Rodriguez, the police chief at that time. I gave her an opportunity to review the report, to ask questions, make any objections, and then we released the report to her. So that was misleading, to say the least. When we talk about victims, I want to point out that the HEART team that I created to have a multidisciplinary approach to addressing human trafficking and domestic violence in this community was disbanded, as was the Gender Justice Unit. There is currently no coordination happening in the Office on Human Trafficking. We were working with the community, specifically the San Antonio Neighborhood Coalition. The human trafficking continues to be a major scourge in this community, and it is not being addressed. And my question for the newly appointed district attorney, I hope someone will ask her, have you met with the family of Nicole Marcy, the young woman who was assassinated, murdered on the street in July of 2023? Because I met with her family, and we took action based on the heinousness of that crime. I also want to point out something that's very significant that happened during my tenure, and it preceded me. It happened under District Attorney O'Malley, but in August of 2023, the grand jury issued a report finding that the district attorney's staff violated county policies regarding the use of county computers and the use of county time to participate in Ms. O'Malley's political campaign in 2018, and that the district attorney failed to provide adequate ongoing training on county policies and state law related to acceptable behavior during political campaigns. That was the finding of the transgressions, the violations under the O'Malley regime. The grand jury found that at least 25 employees under Ms. O'Malley violated county policies and that no action was taken to hold her accountable. Why is this relevant? Because one of the main people that we know participated in those activities and illegally colluded with police unions was Colleen McMahon. And I provided you with the email that was published when we filed our complaint with the grand jury in 2022, and certainly that is publicly available. I'm disappointed to tell the public that the newly appointed district attorney has rehired Ms. Colleen McMahon. And I can share that Ms. McMahon, because I believe she has publicly shared it, she was placed on administrative leave in January of 2023. She resigned her position while she was under investigation. Rather than at the time that we wanted to interview her and find out the scope of the problem, she declined to participate in the investigation and she resigned. She has now been rehired in a leadership position in this office. The foremost expert in domestic violence in this county and in Northern California County has been reassigned from working with victims of domestic violence and training police agencies. She's been reassigned to collaborative courts, where her skills and talents and her knowledge will not be utilized on behalf of the residents of Alameda County. The district attorney mentioned that she was bringing on a new forensic auditor. Well, I'm here to tell you she fired the forensic auditor that had been in place, who was an African-American woman. She talked about the numbers of cases that they are now prosecuting under Proposition 36, and her representation that we are leading the state and have greatly expanded the prosecution of low-level felonies is accurate. However, where is the public dashboard? For more than a year, I was working with different agencies to create a public dashboard so that the media and the public would know how many cases are being brought to us, what type of cases they are, how are the cases being handled. The public dashboard went live in January of 2025 after we had spent all of that time. It showed by quarter, it gave a quarterly assessment and quarterly numbers as to what the cases were. That public dashboard was taken down in April of this year, and it is not publicly available. Where is the website? The newly appointed district attorney talks about transparency. The website that I left in place had over 40 pages, including resources for people, forms, frequently asked questions, all sorts of information, and access to the public, to our office, and to services. That website has been reduced to 2 pages. It is not helpful to not allow the public to have a place where they can file complaints, where they can follow what the district attorney's office is actually doing. The press releases that shows where cases are in fact being filed or prosecuted, they're not there. How are victims of crime being lifted up when they cannot access public information from the DA's office? Most importantly, where is the gun violence report that we issued in November of 2024? What is the status? This is what the public should ask. What is the status of the collaboration on gun violence that we started with the Public Health Department's Department of Violence Prevention? That is a critical issue in this county. People are being shot on the street in broad daylight in Oakland almost every day. And the district attorney is saying and doing nothing about that. She mentions ACOPSA meetings. I went to ACOPSA meetings every month. The district attorney's office is a founding member of the Alameda County of Chiefs of Police and Sheriff's Association. We meet monthly. Every district attorney has been meeting with ACOPSA. That is nothing new. What was new was that we convened 2 gun violence roundtables inviting all of the local police agencies as well as FBI and CHP to participate in a real comprehensive discussion about what are we going to do about gun violence in this county. That conversation needs to continue, in my view. She also discontinued the weekly press conferences and the newsletters, so how is the public supposed to be getting information from this administration? I've said a lot. The call to action, however, which is so important, as we watch this newly appointed district attorney choose to dismiss cases for unknown reasons and then fabricate the explanation why it was done, I call on the public to insist that she continues to hold the Sheriff's Department accountable for the deaths of Maurice Monk and Vanetta Martin. Those cases are pending. The district attorney has resorted to the old ways of receiving funds, political contributions from law enforcement, from the sheriff, but it is so important that she act as an independent prosecutor. And what was challenged for me all of that 2 years was the use of my discretion, which every district attorney in the state of California had, except Alameda County's district attorney. She has the power and the duty to prosecute those cases and not come up with flimsy excuses for why they should be dismissed or say there's not enough evidence to be able to prosecute those cases. She also should proceed vigorously with the prosecution of Officer Fletcher in the Stephen Taylor case. That is a huge case, and it is of critical importance and value to this community that that officer be held accountable and that the message is clear to not only the San Leandro Police Department, but to all of the police agencies that preserving life should be the #1 mission of every police officer. Throughout my political career, I have said, I have maintained the position that I would not publicly criticize another African American woman. In this case, I've had to break that statement. Because in this case, the Board of Supervisors appointed someone with no managerial experience, no personnel or supervisory experience, no financial experience or business acumen to lead an agency, a $100 million agency with 400+ employees. We are seeing just the beginning of the results of that decision. She was appointed by Governor Brown in 2013. She has never had to run for office in this county. She has never had to engage with the public in this county in any consistent way beyond her affiliation with the district attorney's office. And so it is clear to me that her current and her only agenda at this point is to undo the work that my administration did, to undo the initiatives that we brought into being over time. We spent a year working on the Gender Justice Division to benefit the residents of Alameda County. Her only agenda is to undo those things, and that's it. That is not justice, and that is not protecting public safety. For those who will say that this open letter, because I will be publishing my remarks as an open letter to the community, for those who will say that this is just sour grapes, don't be misled. I am doing just fine. As the songwriter says, they whispered, they conspired, they told their lies, but God favors me. And so I stand before you as someone who is part of this community, who will continue to be part of this community. I have a private practice that will sustain me, providing legal services to small and medium-sized businesses. And later this month, we're going to launch a new business called Next Chance Solutions. While our newly appointed district attorney is rebuilding the pipeline in prison, we are building a pathway home for people who have served their time and been forgiven of their crimes, but who remain trapped in a broken system that does not intend to give them the second chances that the law says they're entitled to. And I have a wonderful new podcast and blog, in case you haven't heard, Pamela Price UNFiltered. You can catch it on YouTube and Substack and wherever you listen to your podcast. I will take questions, but I do want to clarify on the Proposition 36 survey data, where we are leading the state in low-level felony prosecution of property crimes. I misspoke with respect to Marin County. They did not respond to the survey. But again, if you compare us to San Francisco, to San Mateo, Solano at 14, it's stark contrast what is happening now in Alameda County that is not impacting public safety. So, questions?
Ms. Price, are you holding this press conference today because you plan to run for DA again?
Not at all. The question is, am I holding this press conference because I plan to run for DA again? No, but the reason that I feel it's important that the public should understand what is truly happening. And unfortunately, I have been silent for almost 6 months, doing other things, but it became clear in the last few days, and certainly with the 100-day report, that there are some things that the public needs to know about. And I've been hearing about the terminations all year, which were not reported by the media, and the kind of climate of fear inside the organization, which the public obviously doesn't know about because it's not being reported at all. So no.
Ms. Price, you sound like you have some very great concerns about Judge Dixon's tenure so far. Have you considered starting a recall process as well? Or something about
I don't hear. I question,
Yes, sir.
Sergeant.
It seems like you have some pretty grave concerns about Jonas Dixon's tenure. Have you considered starting a recall process as well? James?
Have I considered starting the recall process? No.
I understand you. I believe the actions your office took were very important for many reasons, including in the realm of reforms. What would you say to people who see Jones Dixon's administration as taking the office in a new direction following the recall?
What would I say to people who say that the new appointed district attorney's office is she's taking the office in a new direction?
In light of the recall, yeah.
I would say, in light of the recall, I would say they need to look again, because it's not a new direction, it's backwards. She took the organization chart that Ms. O'Malley had and distributed that with no names on it. She dismantled everything we've done and has basically taken everything back to what Ms. O'Malley had. And, you know, where we see these prosecutions under Prop 36, that's a rolling back. The collaborative courts team was disbanded, or I won't say disbanded. People have been reassigned from jobs that they were doing very well. Not having an organized retail theft unit is critical, and that's something that goes back. It's a step backward. And, you know, I don't think the residents of Alameda County understood that they were going to go back to the days when Black people and Jewish people were not allowed to serve on juries. That's the danger that you have. Or when the police got to tell the district attorney what she or he should or should not do. And that's the danger. So we're going backwards. We're not going in a new direction. It's almost what I've said about Donald Trump. Look back at Ronald Reagan. It's the same thing. It's not new. This is a playbook that they have, and she's following it, unfortunately. Yes, sir.
Since you are not going to run anymore, have you identified your team someone that we can, as a community, get behind and support in the upcoming elections?
Question is, since I'm not going to run, have we identified someone that could run? Yeah, no, I'm not running. I am looking, and I certainly would invite and certainly say to any young lawyer or older lawyer. I mean, I was an older lawyer. I had a full career, 40 years. So I do think it takes someone with maturity and experience, both in criminal and civil. But certainly there are people in this community that I would encourage to step up, because justice is on the line. Our community needs a champion for justice right now, and we don't have that in the current district attorney. Okay, this is your opportunity. I'm going back to my garden now.
So,
Thank you very much.
so Pamela Price.
Yes.
So the work that we know that you've been doing with the youth and the community, even the work that you was doing when we talking about anti-trafficking, how can we together as a community start bolstering that work again, since you have an administration that want to push back and forget that work, when we know that when you talking about the Trump administration, they defunded a whole lot of these programs. What is the solution for the people right now?
The question is, given that the efforts that we were making for human trafficking are not being, advanced or amplified in this season, and we know that the Trump administration has deprived funding, and a lot of the nonprofits are losing funding, the cities are losing funding, the county is not, just to be clear, and certainly the DA's office is not. The question is, what can people do now to address human trafficking? Again, we were working with organizations on the ground, like Youth Alive, like Tribe, like the San Antonio Neighborhood Coalition, a number of victims organizations that were there for young people. I would say that we need to band closer with those to certainly try to people need to volunteer at this point, because people don't have the money to pay for the services they need. As I mentioned, there are wonderful psychologists in this community who really want to help these young people and want to help families, and particularly women who are trying to recover from abusive situations. They're professionals, so their capacity is limited. They're doing what they can, but they gotta get paid. For those of us that are not requiring payment, we need to be volunteering. We need to be helping create more beds and safe housing for people. I learned of a situation where a victim of domestic violence went to the Family Justice Center looking for help. She had a young son, and she needed a place to stay. And they were not able to find her a place to stay. And someone had to make a call to a person who does not live in this community who was able to find housing for them. So that's how bad things are. I think that we all need to try to step up, figure out who's doing the work on the ground. Where can you help somebody? Maybe if we need emergency housing. Young girls trying to get out of that business, we need emergency housing. And the new mayor, has an opportunity. There was a task force started under the previous mayor that's been disbanded. So we're just left with nothing when it comes to human trafficking, and that cannot be done. We can't sustain it. Thank you. Yes.
Hi, Pamela Price. My name is Jean Moses. I'm a member of the Interfaith Coalition for Justice in Appeal. And I wanted to mention that the proponents of Prop 36 presented that proposition as a way to offer and encourage treatment for folks with mental illness and substance abuse problems, and that it was going to somehow reduce homelessness. And you mentioned that Alameda County is at the front of the pack in terms of filing charges under Prop 36. Has DA Dixon explained to you at all, she's not explained to us, how many of those charges resulted in people being enrolled in programs to support them in substance abuse or mental illness issues? Again, the stated anticipated effect of Prop 36.
The question is, has the newly appointed district attorney indicated to me, certainly not, but has she indicated publicly perhaps how many of the new Proposition 36 cases that are being filed actually are resulting in people getting treatment, because that is the rationale that proponents of Proposition 36 presented. I can report to you based on the Judicial Council survey data of Prop 36 prior to January 1st, 2025, the percentage of filings that were actually going to receive treatment, it would appear to be 1, 4, and 1%. So that is not happening. What they said would happen is not happening. I can tell you that before, under my administration, we were able to expand the drug court from 1 court to 2 courts. We also used some of the trust fund money to support and sponsor the Bay Area Narcotics Anonymous Convention as a way of reaching out to folks with addictive problems. And we worked with the families of seriously mentally ill to try to provide an outlet and give them insight and a voice in how the county responds to mental illness. The only information I've heard is that from the recruitment process is that the question, the commitment being required of new attorneys coming into the office is a willingness to prosecute homeless people and people with mental illness to the fullest extent of the law. That was articulated in an interview. That's a minimum qualifying criteria to join the Alameda County District Attorney's Office. So there's no indication that people who are in fact being charged with felonies are receiving. Certainly the drug court would have to add a third court, and our courts it took us more than a year to get the second drug court because the courts are understaffed. And so you can't just set up a court to deal with a massive increase in the number of cases. And the system is in fact being stretched and impacted by the influx of felony charges, because that means that the public defender has to take those cases. People are entitled to a right to counsel. So the public defender has to take a case, and if the public defender can't take a case, then the private bar has to step up, and there are not enough attorneys to represent people who are now facing charges in Alameda. Yes.
Just recently in Berkeley, there was a transgender woman that was attacked with a pellet gun. And with a lot of the stuff that's going on with cuts being made, one place that's also seeing cuts being made is the Oakland LGBT Center that helps provide support to our LGBT community. Can you just speak on how your gender policy program, how they were working effectively in the community with our LGBT brothers and sisters?
Question is, given the challenges in funding for nonprofits and the controversy that our new president has created around transgender rights, what was the intended impact or the potential impact of our Gender Justice Division to support LGBTQ communities in Alameda County? It was a great opportunity. That unit was actually staffed by someone who is a member of the LGBTQ plus community, the director of Gender Justice, which I very intentionally selected him. He was a former district attorney of the island of Kauai, so he had that level of management experience to lead up that division. As I indicated, I've worked on that division for a year. It was staffed by many members of the LGBTQ community inside the DA's office. We were working with community. Our community outreach certainly included that component as well. That division has now been dismantled.
And how many LGBT employees lost their job with that being disbanded?
Well, they were reassigned, is my understanding, and I'd have to look at my list and see who actually was terminated. But I know that at least 3 people that were assigned to that unit are no longer there. Meaning they're in the office, but they're not working on gender justice. As far as I know, no one is.
I believe you provided this, but just to make sure I got it all correctly, could you provide the names of the defendants in the cases that Judge Warner reviewed?
I did, and I do have that. I didn't bring all of that paper, but Braylon Winbush is one of the ones that is currently on the subject of a motion to remove this resentencing recommendations. And I cannot emphasize, it took us months to review these files and come up with recommendations. Some of them were negotiated settlements with Judge Chhabria. So to just, it's clear, there is a case that absolutely speaks to this. It's called People versus Vassal, I believe. And that case clearly says that it's improper for a newly elected or appointed district attorney. A change of administration is a political event that should not result in a change in the sentencing recommendations. So we do have that law. It's Judge Horner. Presided over the Braylon Winbush case, the Delaney Marks case, the Michael Martinez case, and the Ernest Dykes case.
Thank you. Can I get this spelling of the person? Sorry.
Graylin, Graylland, Winbush, Winbush. And I would say this, that the team that worked on those resentencing recommendations, which included Amy Solway, who was the district attorney who discovered the notes in the Ernest Dykes case, she has left the office. All of that team has been reassigned and left the office. They successfully handled all of the resentencing cases under my administration. Their work is now being questioned and criticized, but it was not questioned or criticized by the court. And in fact, Judge Stevens approved those recommendations. And where he did not, there were modifications made. But now to take a wholesale approach and say that everything they did before was good, but everything that they didn't finish is bad, is illogical.
And then I've also heard similar
what I have learned, what I've been told is that 20 were successfully approved by the court, and there were approximately 10 that are left. Those are the death penalty cases. Then we have, again, under the statute, the district attorney and the Department of Corrections and the court and the Board of Prison Terms can recommend people for resentencing. And so that's the universe. When I came into office, I was told there were 25,000 people sentenced from Alameda County that are eligible for resentencing. That was 2 years ago. So we didn't do 25,000 or 2,500 people. I apologize. We did not do 2,500 cases in 2 years because it takes a long time to do the cases, and we very carefully vetted people before we made the recommendation or before we made a decision not to oppose a petition. And to say that now there will be no consideration of any resentencing petitions is just really a miscarriage of justice. Thank you.